All right, then, Mr. Amberg, please your response.
Thank you, Your Honor. Although I would rest on the pleadings themselves, I would indicate that I wholeheartedly disagree with the people's position that they provided any type of legal mechanism to suggest that we somehow violated their right to a fair trial. Although they cite the Michigan Rules of Professional Conduct, from the research that I've done on this case and in this particular issue, whatever the rules of professional conduct may dictate, that is not the proper mechanism as far as getting a gag order in a criminal case. If the people have a problem with whether certain statements might be violative of the rules of professional conduct, that would be something that would be dealt with through the Bar Association. I read cases from the U.S. Supreme Court regarding that. Now, Ms. Holbrook has numerous constitutional rights that are enforced in this case. Number one, she has a right to free speech. And not only does she have a right to free speech, but Mr. Williams does, as well as myself. In addition to that, the Sixth Amendment guarantees a right to a public trial. Now, that's not a guarantee to everybody. That's a specific individual guarantee to the defendant. Just like with free speech rights, those aren't rights generally given to the government. If you look in our brief and how the Sixth Circuit addresses that, and I believe that's probably on page 2 of the actual brief, and I'm going to quote this. It is the individuals, not the government, to whom First Amendment interests attach. To the extent that publicity is a disadvantage for the government must tolerate it. The government is our servant, not our master. Now, as far as whatever precedential value you want to put on the people's brief, they put a lot of weight in the, I believe it's the Coretti case. Now, the Coretti case is a district court case from the Eastern District of Michigan. And the Sixth Circuit, that's their superior court right there saying that. Now, I'm familiar with the Coretti case. That gag order was issued, that's the terrorist case. And it was in front of Judge Rosen, and that gag order was issued in post-trial appellate situations where I believe they had information that might have been at issue with national security. I've been involved in numerous cases involving the media, Your Honor, and obviously this case involves the media. Certainly on TV, on the radio, and the newspaper. It's been my experience that both the people and defense counsel make statements. In fact, in this case, within hours of the incident, the people not only had made numerous statements through the police, they came in here and they didn't suppress the file, and out came evidence, uninvestigated evidence at the original arraignment. And obviously from that, the media took hold of it and then ran the story. Now, if the people are so concerned that some type of facts should come in that might not come in at the trial, then why did they do that? The statements that were made by Mr. Williams were not specific factual statements. They were general statements. I've been involved in one case where I sought to get a gag order. It was a situation where a detective had disagreed with my method of bringing my client in for an arraignment where my client got a personal bond. And in retribution for that, the detective went and took the police report, which at the time was confidential and not part of the public record, and took it down to the newspaper, and they ran it. Now, in that case, with a much more egregious violation, because I don't believe anything egregious happened here, the judge did not grant the gag order. So, although the people obviously are concerned with the media, it was never any intent on our behalf, and nor will it be. Both Mr. Williams and myself follow the Michigan Rules of Professional Conduct. And I would just, to close with it, Your Honor, to accuse Mr. Williams' statements of violating that when the people have put out all sorts of statements right after this happened without doing any type of investigation, I find that to be akin to the pot calling the kettle black. And I would ask, Your Honor, that in lieu of suppressing my client's and our First Amendment rights and her right to a fair or a public trial, which she's not objecting to, Your Honor, there is nothing that the people in this particular situation that overrides those fundamental rights.
Thank you. Mr. Doherty, any response?
I think our brief is pretty succinct in as far as the motion as well, and attachments speak for themselves, Your Honor.
Okay, so then we'll just have anything in summary or in closing other than your...
Yes, Your Honor, I would ask that the court simply enter an order that requires the participants in this matter and their agents to follow MRPC 3.6, which states in part that as far as, I suppose, following and making sure that extrajudicial statements that are made are not disseminated in a way that would substantially have a likelihood of material prejudicing what we would call our jury array or prospective jurors in this matter. Thank you, Your Honor.
Your Honor, I would indicate, if that's the people's position now, because what they're asking for in this motion is not that. They're asking for any statements at all from the defendant and the defense to be suppressed. Nothing to the media at all. Nothing regarding letting the media know how to put things out as to Joni's well-being, how to help her, and things like that. Now what the people are asking for is for both Mr. Williams and myself to follow the Michigan rules of professional conduct. Your Honor, we don't need an order for that. That's something that we're bound to do just by having our bar license. If Mr. Doherty believes that we violated that, I would say that his recourse for that is not in this court. It is in Lansing with the Michigan Bar Association. However, I highly doubt they would even consider given the situation that these statements are that were made were not inappropriate at all, and his statements, on the other hand, were much more egregious. You know, when you look at all these cases that involve releasing statements to the media and pretrial publicity and things like that, the judge's main concerns in that, the court, you know, with the Court of Appeals, even the Supreme Court of the United States, their main concerns are with evidence that's going to taint the jury and evidence that's not going to come in and things like that. That's not what's going on here. There were two general statements that mimicked each other. Whether it's on TV, whether it's in print, they were general statements. Just like the police made a general statement within hours of this. Just like the prosecutor made within hours of the incident. So I think it's wholly unfair. I question why we're here, and Your Honor, I respectfully ask that you deny this. And I would also ask, after the conclusion of this motion, if we're given an opportunity to address bond as well. Thank you.